Our next speaker and final speaker is Dominic. And Dominic, I will pass things over to you. I have no smooth transition. That's the best I can do now.
That's why I'm here. Thank you very much. My father, when I was growing up, always used to call me Tail End Charlie. 40 years later, I still see I'm right at the back of the queue, and we'll be trying to rehash some of the same material, but hopefully in a different and still interesting and relevant way. I think I've been announced today in the program as speaking purely about investment treaties, which I'm happy to do, but it just seemed to me that small states and developing states have such a wealth of different challenges before them that it made sense for me to try and pick up from where Stephen left off and look at a rather broader range of problems which small states may need to grapple with in the context of dispute resolution, and how best they might think about maximizing their prospects of a successful claim or defense. So the way I'm going to deal with dealing with a rapacious state is to look very briefly at investment claims first, and then try and broaden out the discussion a little bit in terms of how one deals with them, how you could avoid trouble in the first place. There's some quite interesting laws of unintended consequences which we'll look at, fighting the case, and then a couple of concluding thoughts, all to be achieved, I think, within 20 minutes. Is that right, Jansen?
That is quite right.
Okay. So without further ado, investment treaties, which is why I'm here, this is something that my firm has quite a lot of experience of. I thought it would be good just to have a quick reality check. There is, for those of you who are not aware, UNCTAD are very, very helpful in publishing sort of snapshots yearly on the state of the investment arbitration market. This is from last year's publication, which looks back at the state of affairs as of 2014. And here, it's quite interesting. The relative share of cases against developed countries is on the rise. In 2014, 60% of all cases were brought against developing and transition economies, and the remaining 40% against developed economies. That is probably good news for the smaller state, in that it's the larger places who are now being hit more and more frequently. As of the end of 2014, this is UNCTAD's own bar chart. They're rather better at the whizzy stuff than I am. Argentina and Venezuela still in pole position. And then a number of bigger states going right the way down through to the United States. There is not a small state amongst them, which, again, I think is interesting, notwithstanding the doom and gloom that we've heard already today about how smaller states may have got themselves in a bit of a mess, and I have another anecdote to share with Lauge later. If we now look at where we are today, the truth is most small states have had very few investment claims made against them. Argentina and Venezuela are still in pole position, but you have to go right down to 22nd equal. It's not really a race, but it's the best way of ranking them. Costa Rica with 9 cases. The last, I think, 5 of them in the last 3 years. Now, therein may lie a couple of tells we can look at. You've got Albania, and then you go down 47th equal, Belize and Macedonia with 3 each, and then right at the bottom, Grenada, Trinidad and Tobago, Cape Verde and Lesotho with 1 each. Interestingly, nobody seems to mention the claim against South Sudan brought by NALPET, presumably because it was under an investment law, I don't know. But it is odd that it doesn't seem to feature in any of the published materials outside of the ICSID website, but that's as may be. So are there any emerging themes that we can glean from the statistics, bearing in mind that Churchill's line that there are lies, damn lies, and statistics? Well, I think it may be fair to say that economy size may have a lot to do with the number of claims that are brought against you. The bigger your economy, the more likely you are to have inward investment, and the more likely you are then to have investors who are perhaps less than gruntled. There is a greater understanding of investment protection and investment claims. I was based in Asia for 12 years. When I went out there in 2003, nobody knew a thing about investment claims, let alone bits or bit structuring. That's something that I've spent quite a lot of time doing, particularly from Japan and in China as well. And it's interesting now to see that these claims are starting to come through. But there you have it. It's education, education, education. bringing claims, and claims. The nature of the investor, there are more and more individual investors that I've seen. Costa Rica seems to attract them rather more than most. It may be just the way that the cases are cited. And there are repeat claimants. I don't want to say anything out of turn, but there is a company called RSM that has brought at least 2 ICSID claims, one against Grenada and the other against, I think, the Central African Republic. But that seems to be very much the nature of RSM's business, is litigation rather than oil exploration. And then there is treaty shopping, where it goes back to the educational point, which is that the more you understand the process, the more you can try and protect your investment and find a way where there is a country with relatively limited bits to find a way to obtain bit protection. Doesn't always work, but it seems to be something which is coming out of the cases a little bit. So with all these claims coming through, what then? How do you deal with them? Well, I think it's a commonplace that one of the principal constraints upon the small state is resource in many respects. I think Stephen talked about clout, economic, military, and of course financial. And it is fair to say that investors in wealthier states may often be represented by large international law firms or very well-known practicing lawyers, both in their own country or from the United States or the Western world. And often we'll have academic and professional advisors as to damages, as to hydrography, who knows what else. Whereas smaller states may perceive that their resources will not be able to hire a similar level of advisor. And there I found Brian's talk very interesting about the theoretical options available to obtain funding. We can talk a little bit more about what that may look like. That said, there may be no need to seek or pay for external help in certain situations. It may be that the expertise already exists within the government. I mean, certainly some governments I've worked with for smaller states, Singapore, for example, has plenty of experience, but is not shy also to get its own specialist advisors where necessary. Where expertise has been acquired, I think it's fair to say that there is one state which has a number of ICSID and UNCITRAL BIT claims made against it. It's now so well versed in how to deal with those claims that I think it's almost got to the point of doing them on its own on the back of, let's call it, lessons learned. If expertise is available through other means, that's an echo then of Brian's talk. There are international organisations. The Commonwealth is one that does offer quite a lot of support, albeit on the non-contentious front. Private investors with an aligned interest. Now there, I think small states need to be a little more careful. The better oil companies, particularly in a boundary dispute situation, will not wish to back one state against another, in my experience. What they will tend to do is try and facilitate discussions between both states and try and ensure that they are not perceived to be offside against one government or the other, not least because if the boundary gets drawn at an angle that doesn't suit them, they may well not end up with rather less oil than they were hoping. So it makes sense to try and back both horses and to hedge against loss on that basis. And then pro bono representation. I know at least one firm that has done a pro bono representation of, frankly, an international sovereignty dispute. They did it very well. I would caution that often you pays your money and you takes your chances, and the less you pay, sometimes the less easy it may be to justify a bad result. So sometimes the Stella Artois of legal representation may be the right way to go, that if it's reassuringly expensive, you can't be blamed for having missed a trick somewhere. But whatever team you decide to put together, the small state should ensure that its negotiating and litigating team is not outmatched by the opposition. Now, there are some useful lessons out there. This one excerpt from the delimitation of maritime boundaries within CARICOM from the regional fisheries mechanism is, I think, good advice. Where national or regional expertise is not available, the services of competent advisors in the appropriate legal, hydrographical, or technical field should be secured to assist the conduct of the negotiation. Now, against that, you have this excerpt here about the Faroe Islands and their spat with the EU over migratory fishing stocks. A well-placed source told me, it wasn't very well reported, but I had heard from a number of different people that the Faroe Islands had tried to do the case on their own without help. I heard also the kinds of arguments that they were running, and it came as very little surprise when this headline reached me that the Faroe Islands had dropped their claim against the European Union. It was always a difficult claim. The arguments that I heard that they were running made it, to my mind, much more difficult. So, preparation is key. Use the best data and have it interpreted and presented by the best advisors that you can get in country, regionally, or otherwise. And it is important then to have a really first-class team. Certainly investment disputes, boundary disputes, other state-to-state disputes, it's rarely a showdown between one lawyer and another. It's much more about, as you can see there from the CARICOM excerpt, a number of different players within a team, all of whom have to work together to get the best result for the state client. Otherwise, things go wrong. Avoiding trouble in the first place. Now, I hope there's nobody here from Timor-Leste that is going to be embarrassed, but there is a lesson to be learned. Question: what kind of advisor should you hire? Answer: the best available. So, who are you dealing with? Well, Timor-Leste somehow got embroiled with a Nigerian American by the name of Bobby Boy, who in addition to scamming them, I think it was about $3.5 million that they know about, also managed to get Timor-Leste into a spat with its best customers, namely the oil companies, over a series of tax disputes, at a time when Timor-Leste is also fighting Australia on one, the ICJ arbitration and now conciliation. I think for a small country to take on that amount of litigation burden is plucky, to say the least. What they really didn't need to do was to take on all the oil companies on the back of fraudulent tax advisors' advice. So, who are you dealing with? Check them out. Practitioners, I think, certainly of Stephen's standing. There are others who've been talking here over the last day or two. I think there should be no question about their integrity, their experience, or their ability to help. So the reputation is also very important. What is their motivation? If your name is Bobby Boy and you're in it for the money, that's probably not a good reason to hire somebody. If they're there genuinely because they want to help, that may be a good reason to giving them a second interview along with other people. And what do you really need them to do? That may sound like a very odd question, but actually it's well worth considering. Do you really want to get in a fight with your neighbour, or is there the possibility of an amicable resolution? Do you want to take on your big neighbour next door without, in a maritime boundary dispute, without first trying to see if you can't delimit the boundary? There will be, as Stephen will tell you, a threshold question whether or not the UNCLOS or ICJ would have jurisdiction in any event if you haven't tried to negotiate to show that there is a dispute. But at least think it through. What do you really want your advisor to do? And have you got the right person? No point having a street fighter if actually what you want is a very civilized discussion. In that regard, look at the ICSID report of RSM Grenada, and you can see how best not to carry on interstate discussions with a wildcat advisor. Lessons from West and East Africa. What has been really agreed or decided? Now, there's a couple of quite odd tales coming from this. Treaties. Well, if you are going to try and resolve your problem, often that will be through some form of interstate agreement, possibly investor-state agreement, to resolve the dispute. Certainly with a treaty, you will need your representative to have full powers. What you don't want to end up happening is the signing of an MOU which years later you think is perhaps, on reflection, wasn't a particularly good idea, And then you have to resort to what the Somalis did in paragraph 7 of their protest note, which you'll see on the CLCS website, complaining that actually the guy that signed that MOU really wasn't empowered to do so, and on second thoughts, let's have another go. It's punchy. Boundaries. The reason why you need more than lawyers is because you're dealing with geography. Geography is something I gave up at 13, so I really couldn't help any of you with. But it would appear that so has the ICJ forgotten some of its geographical lessons. You'll all be aware of the need for a datum and the lessons of Cameroon and Nigeria. So even with the best lawyers in the world, bar none, they delimited the boundary between Cameroon and Nigeria, forgot to give a datum, which then created all sorts of problems because nobody knew exactly where the line was supposed to run. So again, that's where you need a full team to ensure that you get to the right result. Now, Stephen has already spoken about jurisdiction. I'm not going to say very much about it. I would say, however, that the first step towards successful dispute resolution is picking your battleground. Where do you want to fight? Where do you think you will be most comfortable? Is it national courts and tribunals? Is it in arbitration somewhere? Do you want to go to the ICJ? Are there reasons for not going to the ICJ? For example, there's always the risk of intervention by a third party, which you won't get in an arbitration. So there's lots of things to think about in your submission to the other side. There's also the law of unintended consequences. Thailand, as you know, has not ratified the BIICL Convention, signed a BIT with Egypt, and lo and behold, a Thai investor had a problem in Egypt, which I think is quite well publicised. Lo and behold, they had no recourse except to the competent courts of Egypt. So that was a claim that was never brought. So do beware that when you are agreeing these provisions, that your own protection of your own litigation risk may affect the very people you are trying to assist in other states. And then finally, particularly if you're arbitrating, but also if you're litigating, know your judge or arbitrator. That's where the value of an experienced legal practitioner will help you, because they will know exactly the kinds of arguments, and the way to frame those arguments will be most successful. Very quickly, I think I've got all of about 3 minutes left to get through 4 slides. Protecting your position. There are a number of provisions under the different arbitral rules, under UNCLOS and the ICJ statute, for provisional and interim measures of protection. They have been used, I think it's fair to say, sparsely, if sparingly, by states in investor-state disputes. The one obvious example is Mafazzini. I think there are some examples in the Iran-US claims tribunals, but it is something for you to think about in terms of putting pressure on the investor who may be suing you. With state-to-state disputes, they have been used, they are encouraged, particularly under UNCLOS, and where, as is the case very much now, there are submissions to the CLCS. Don't forget the CLCS rules, Annex 1, Rule 5. This is a note verbal that I helped to draft, where it really stopped in its tracks the consideration of Myanmar's extended continental shelf submission, because we said that there was a dispute between Bangladesh and Myanmar, as a result of which the CLCS had no competence to take the submission any further. That's something which is very relevant today in the Argentina-United Kingdom CLCS consideration. Best evidence. You need maps, you need evidence. Don't make it up. That's the rule from Qatar and Bahrain. I do have copies of the slides for those of you who want them. I can send them on to you for those of you who are interested. But when we have more time, paragraphs 6 and 7 there are a bit of a hoot and are a lesson in the importance of the best evidence rule and making sure that your evidence is authentic. Fighting on, even when it's all over. It's not over. There is generally no right of appeal in international law disputes, but you can street fight in other ways. You can go for annulment, possibly, under the BIICL rules. There are interpretation and revision provisions under the other rules, BIICL, UNCITRAL, the ICJ. Very famous example where I think it must be 50 years after the ICJ decided the Temple of Priya Vihar case between Thailand and Cambodia, lo and behold, bang, there was a request for an interpretation, which brought the whole thing back together again. So it's never over until it's over is the short rule. Keep calm, never surrender. And then my last slide, what does successful dispute resolution look like? I would not only echo but endorse what Stephen said about, there's never a perfect solution. Frankly, I think you don't want anything which is too extravagantly one way or the other. As a boundaries lawyer, I would say good fences make good neighbours. If it's all one way and not the other, it's going to breed resentment. There's going to be more trouble later. Actually, something which is not an outright win may be a better win than something which is. So something may have to be conceded. Often that is the way that these decisions go. Whether you have to take it all the way or you're able to agree a settlement along the way, the important thing is political acceptability. It's all very well thinking you've done the deal of the century for your state or your government, but if the punters don't like it, you've got a problem. So that may be a good reason, actually, for taking it to the ICJ or arbitration and risking a loss. Thank you very much.
Thank you very much, Dominic.